Hey guys, my name's Alana and today I'm going to be talking to you about salvage. So what is salvage? It's the rescue of vessels or cargo in peril at sea and the reward thereof. The law of marine salvage is primarily concerned with property salvage, life salvage, and treasure salvage. There's pure salvage and contract salvage. Pure salvage is strictly volunteer, and contract salvage means that parties have entered into an agreement concerning the salvage efforts. Valid salvage under the General Maritime Law states that there must be a marine peril placing the property at risk of loss, destruction, or deterioration. The salvage service must be voluntarily rendered and not required by an existing duty or special contract. The salvage efforts must be successful in whole or in part. There is a time limit for the suit, and a suit for a salvage award must normally be filed within 2 years of the date the service was provided. So what property is subject to salvage? It's a very broad spectrum in the term of maritime property. And as mandated by the Supreme Court, only maritime property can be the object of an act of salvage, although there has been no adequate definition formulated for maritime property. According to the textbook, maritime property is whatever of value found in or upon navigable waters that is property within Admiralty jurisdiction is subject to the law of salvage. So, who may be a salver? Any person, including a corporation or governmental agency, that performs an act of salvage may qualify for a salvage award as long as he was under no pre-existing duty to pursue the act in question. Persons performing services in the line of their assigned duties are not entitled to salvage awards. So if it's contracted salvage, then they already have a duty or an agreement to do so. There would be no award. Salvage negligence and misconduct. Undertaking a salvage effort means that the salvage will be performed within reasonable care and skill. A salver is accordingly liable for ordinary negligence in carrying out the salvage operations. All damages assessed reduce the amount of salvage award. If salvage is attempted but not successful, then the salver is not liable for losses sustained either by the owner or third parties in the absence of sustained gross negligence or willful misconduct. There are economic incentives to avoid fault or negligent conduct in salvage operations, such as insurance of risks. So a lot of contract salvers will get insurance to cover themselves in the event that they'll be charged with negligence or to avoid such charges. The salvage award. So a court determines if a salvage service has been rendered, and from there, there is a just and proper award that must be fixed. So although there is no specific rule for determining the amount of the award that can be given, this is due to unique circumstances for every different salvage case. The traditional criteria for an award are the time and labor expended by the salvers in rendering the salvage services, the promptitude, skill, and energy displayed in rendering the services, and the saving the property, the value of the property risk or employed by the salver, and the degree of danger to which the property was exposed, the risk incurred by the salver in securing the property from the impending peril, the value of the property saved, and the degree of danger from which lives and property are rescued. And in addition to the 1989 International Convention on Salvage, Article 14 came into play, where there is special compensation for a salver who prevents or minimizes damage to the environment. Contract salvage is when the salver acts to save maritime property after entering into an agreement to use best endeavors to do so. So, in pure salvage, there is no pre-existing agreement between parties, but contract salvage means that there is, and it's already been put into place. Although contracts within Admiralty jurisdiction, the most common is Lloyd's Open Form 2000, which provides for salvage contract disputes by the courts. LOF's standard agreement provides that the contract salver is engaged on a no-cure, no-pay basis. The salver is only entitled to compensation if he is successful in whole or in part. There are special considerations that salvers may be entitled to, with exception of the no-cure, no-pay rule, incorporating a scopic, or special compensation protection and indemnity clause agreement. This exception is typically made when the salver prevents or minimizes damage to the environment. Life salvage occurs when someone who saves life when no property is saved is known as a pure life salver and has no claim against the person saved nor compensation from the owner of the ship or its cargo. The textbook stated that there is a duty under both international law and domestic law to endeavor to save life at sea. And the Standby Act requires a master or person in charge of a vessel, so far as he can do so, without danger to his own vessel, crew, or passengers, to render assistance to every person who is found at sea in danger of being lost. There is no award to pure life salver, but it is an obligation and duty of one to do so. So my current event was a cargo ship, MV Golden Ray, that capsized on September 8th in 2019 while it was departing the port of Brunswick, Georgia. And recently news came up because one company is saying that a different company is not following environmental regulations. So after the incident, salvor experts and the United States Coast Guard concluded a detailed plan needed to be made to salvage the ship. And a salvage company, Don John Smith, filed a complaint in February of 2020 in the U.S. District Court asking for a judge's injunction to stop any removal efforts of the vessel. The company claimed that the United States Coast Guard would be violating a 1990 federal law in regards to oil spill response. The owner hired T&T Salvage to remove the vessel solely because they agreed to move it in larger chunks than anyone else would, which were up to 4,100 tons, when the courts deemed that it needed to be removed in 600-ton pieces. So this contract went against what was already decided by the courts. Don John Smith made this legal claim, pleading that all of the cars and other cargo on the ship needed to be safely removed to avoid environmental disaster. Neither the Coast Guard or T&T Salvage had made any comments regarding to the claim or future plans for the salvage. It's just been under the radar. So how does this relate to maritime law and marine salvage? So Don John Smith is a rival salvage company with T&T Salvage, so they saw they were doing something wrong and wanted to step in and, out of the goodness of their hearts for the environment. And they looked into the international salvage conventions that T&T Salvage would be violating if they went through with their contract salvage to salvage the MV Golden Ray. And the 1989 Salvage Convention was developed, as I stated earlier, in concern for the environment and the necessity to introduce environmental protection as an important value to marine salvage. This convention supports an effective and timely salvage operation, but promotes minimal harm and damage to the environment. So if T&T Salvage were to follow through with the contract in place, which goes against the court's order, and salvage the ship in bigger pieces than allowed by the law, then they would be exposing the environmental oil spills and violating this convention. So more news will be coming out about this, but I think that overall TNT Salvage will probably still do the salvage job. They'll just change the amount of pieces that they'll take the ship out in so that they don't face many fines and potential oil spills to the environment. And these are my sources. Thank you.